Good morning and welcome to today's Ask a Pro webinar. Today's topic is how to manage motions for relief from stay and reaffirmation agreements, a guide for creditors. My name is Monette Cope and I will be the moderator today. I'm a bankruptcy attorney with, believe it or not, over 30 years of experience, and I practice out of the firm's Chicago office. I represent banks, financial service organizations, and student lenders nationwide. I'm a member of both the American Bankruptcy Institute and the Chicago Bar Association. Before we get started, I'd like to take a moment to go over a few housekeeping items. As a reminder, this is an interactive session, so please submit your questions through the question button in the control panel. Questions will be addressed during the presentation where applicable. This webinar is being recorded. At the conclusion of today's session, a link to the recording and a copy of the slides will be sent to all of you. Lastly, there will be a short survey on your screen at the conclusion of the event. Please take the survey and share your feedback. We greatly appreciate hearing your opinions on our webinars. Now, let's learn a bit more about our panelists. We'll start off first with you, Garry Masterson.
Good morning, everybody. So I've been with Weltman for approximately 4.5 years. I practice out of our Cleveland office, and I also primarily handle bankruptcy matters in the state of Pennsylvania, New York, California, and Ohio. However, I also can represent nationally as far as reaffirmation agreements. So if you ever have any questions, feel free to reach out.
Okay, thank you, Garry. And now how about you, Erin McCabe?
Yes, thanks, Monette. Again, my name is Erin McCabe. I am a bankruptcy attorney with Weltman, of course, in the Cincinnati, Ohio office. And I generally cover Kentucky, Eastern and Western District, and Northern and Southern District of Indiana. I've been with Weltman for approximately 10, going on 11 years now, and glad to be here. So thank you for all coming.
Okay, great. Thank you, Erin. Okay, without further ado, let's get into the first question. Okay, and this question is for Erin. Does a creditor need to file a motion for relief from stay if the vehicle was repossessed prior to the filing of the bankruptcy case?
Well, that is a great question, Monette. I'm going to say this with a star, but the answer is yes. And let's first of all separate between a Chapter 13 and a Chapter 7. So, traditionally, Chapter 13's a repossession prior to bankruptcy was a violation of the automatic stay provision under 362A3, which basically says, it was an exercised control property of the estate. In a Chapter 7, it's a little less unclear. However, that same rationale applies, that it is a pre-petition control over a property of the estate. So generally, for instance, in a 13, I would recommend filing a motion for relief. In a 7, I would do the same thing. However, if you look under a Chapter 7, I would go to the statement of intent and see what the debtor intends to do with your secured asset. Are they surrendering it? Are they reaffirming it? And that may change my answer. If they're trying to keep the vehicle, ask you to turn over the vehicle, and they're surrendering it, then my answer might be a little different. I would resist that. One of your alternatives is to file a emergency relief from stay immediately and keep the vehicle. You have to kind of know your judges a little bit and how much you can push on that, but that would be my suggestion. That would be sort of an emergency relief from stay. In a 13, I would probably file for relief, immediately, but I'd also turn over the vehicle. You can ask for adequate protection, that is, meaning, ask for proof of insurance. I understand there's some jurisdictions that are less tolerable about that, but certainly you want to know that your vehicle is insured before you turn it over. So, okay, I said this all with a star because there was a Supreme Court, case that was rendered, I believe, in 2021, January 2021, the city of Chicago versus Fulton. And it was basically a case that had to do with thousands of dollars worth of unpaid parking tickets, basically. And the city of Chicago repossessed the vehicle, and then what they do, they file bankruptcy and ask for the car to be turned over, immediately. And there was a split between certain jurisdictions. I think the Seventh Circuit, where I think that's up your way, Monette. You would probably know more about that than I do. But it made its way to the Supreme Court, and the Supreme Court basically said that, just having possession pre-petition of a vehicle is not a violation of the automatic stay. So, it prohibited affirmative acts that basically would disturb the status quo. So just holding the vehicle was not a violation, which sort of clouds everything I just told you all a little bit. So, I think it takes an affirmative act on the debtor side, for instance, filing an adversary against you, or a request to turn over the property. So it requires something on their part more than just picking up the phone and calling you. Having said that, my recommendation, of course, is cheapest, is just to go ahead, return the vehicle, and file for relief immediately, unless you have some reason that you want to push this, harder. So that's generally what I do. I just had a case recently where somebody filed a Chapter 7, and their statement of intent was to keep the vehicle, to return the vehicle. And, we basically had the client file a motion for relief immediately, and, we turned over the vehicle. But I think it's a question of how much you want to push it and how safe it is to do that without having the debtors council raise a fuss. So.
Yeah, I would agree with that, Erin. One of the things that you would want to consider in a Chapter 13 is, does the plan provide for the vehicle? If it does, you may want to just go ahead and turn it over without a lot of fuss, because the debtor may be relying on that vehicle to go to work and fund the Chapter 13 plan. There are a lot of different scenarios that could occur, but I think the big takeaway is you don't have to return the car just because they ask you to. They have to take some kind of affirmative action. That being said, you don't have to require them to do that if you see that they actually are providing for the vehicle and they need it. That would be probably the right thing to do, unless there are other issues in the case. Another question for you, Erin. In a Chapter 7, how would you factor in getting a trustee abandonment if you're leaning towards not getting relief from stay? What about that trustee abandonment? Can you comment
Certainly.
on that?
If you want to keep the vehicle in a Chapter 7, you have to deal with the fact that it's property of the state still. So you need to you can file a motion for abandonment with the trustee, or perhaps get an agreed order abandoning the property in the 7. Remember, the trustee, once they file bankruptcy, your pre-petition asset, your vehicle, is property of the estate. So it's not just an issue with the debtor, it's also an issue with the trustee, because your attempt to keep that vehicle and sell it, would be, that certainly would be a stay violation. So you've got to get this trustee basically to sign off on the fact that he doesn't want any interest in the property, and he's abandoning it. So I would certainly want to get that as well, or you can hold it to discharge and the 341 meeting when the trustee issues his abandonment and notice.
Okay, thanks, Erin. All right, let's go to our second question, and this is a question for Garry. What should a creditor do if they receive a notice of insurance cancellation for a vehicle while the bankruptcy is still pending?
So at the outset, before we even get into any details, if you receive this sort of notice, you're best to act on it immediately. Reason being, your vehicle is now out on the road at complete risk of damage, being totaled, disappearing, and with there being no insurance in place, you're more at risk than ever. So if you receive a notice indicating that either insurance has been canceled, you've been removed as a lien holder, or there's been other negative changes, you should immediately either contact debtors counsel yourself, or our office is always willing to reach out as well and ask for proof of insurance, also showing that you're a lien holder. You should also give them a really short rope on getting back to you. If you're not hearing back, I would follow up with another email the next day. If you're not hearing anything to that first email and the second email, then I would strongly advise that you send the account over for us to file a motion for relief from stay, and the basis there would be adequate protection. You're not adequately protected because you do not have insurance coverage on the vehicle. Many times what will happen when you do file that motion is, even though your emails or your other communication with debtors counsel didn't prompt them to get coverage on the vehicle, that motion usually will prompt them to go ahead and do so fairly quickly. Also, many times at the meeting of creditors or 341 meeting, many trustees will also require proof of insurance for the vehicles that are in the bankruptcy. However, don't rely on that. I've been at many 341s in Western PA where they're verifying everything else they need to verify. They're never asking for insurance. So at the end of the day, if you get that cancellation, don't sit on it, move on it. Your collateral's at risk. And also I would add, if there's any other reason that you believe you need to ask for proof of insurance, go ahead and do so. For example, like we were talking about, your vehicle was repossessed. Perhaps you're returning the vehicle, maybe the arrears were cured, the return has worked out another way. I always ask for proof of insurance. The worst answer you're going to get from debtors counsel is, no, we're not providing that. But I've never received that answer. Usually we receive proof of insurance really quickly. They want their car back. And along with that, I've seen situations also where a car is repossessed. Before we can even file for relief from stay, they've already gone and canceled their insurance the next morning. So just be aware of that. Ask as soon as possible, and if you receive pushback or if you're not receiving any answers, go ahead and get that over to us so we can make sure to protect your collateral.
Okay, thank you, Garry. All right, we are going to move on to question number 4, or question number 3, I'm sorry. And this is for Erin, does a creditor need to file a motion for relief from stay in each active bankruptcy case if each of the co-debtors have their own separate case?
Yes, yes. In short, it's probably easier to give you an example. Perhaps a father and son are on a contract, car purchase or something, contract. Son buys the car, dad co-signs, and then the son goes out and files a Chapter 7. And then maybe the father files a Chapter 13. We see this a lot of times in divorce cases too, where husband and wife each file their own bankruptcies. But in short, the son that files a Chapter 7 the automatic stays in place, so you're going to need relief in that bankruptcy case. And then in the 13, you'll also need relief and co-debtor relief, because there is no co-debtor relief in a 7, but there is a co-debtor relief to protect the co-signer in a Chapter 13. So you'll need both relief in the 7, relief in the 13, and co-debtor relief in the 13 as well. One more example, the same line of reasoning, if you had 2 Chapter 13s, you would need relief in both and co-debtor relief for each other in both. So unfortunately, it is an added expense, but that's what's required.
Right. Every single bankruptcy has its own automatic stay. And in every single Chapter 13 bankruptcy, there is also its own co-debtor automatic stay. So, correct. It's not economical, but it is necessary. All right, moving on. We've got question number 4, and this is for Garry. Does a creditor need to file a motion for relief from stay if a debtor is surrendering a vehicle?
So the short answer is yes. However, there's different situations based on which chapter you're dealing with. So if your vehicle is in a Chapter 7, you have a couple different options. If the debtor is surrendering, whether they've actually already turned in the vehicle to you or a dealership, or their statement of intent is to surrender, you can either file for relief immediately, or you can wait until the case discharges. One of the factors that I always advise clients to look at is, when is the case going to discharge? And do you have your vehicle? If it's the very beginning of the Chapter 7, and for example, the case might not discharge until November, I would recommend that you file for relief. First, you're going to be able to liquidate your collateral much sooner, but also if it's a situation where the debtor has expressed their intent to surrender, but you don't have possession of that vehicle, your vehicle is still at risk. And things just have a way of happening between bankruptcy being filed and you securing your vehicle. In a Chapter 13, little bit different. Generally, in many jurisdictions, if your vehicle is listed as a surrender in the Chapter 13 plan, usually you will have relief and co-debtor relief from stay once the plan confirms. Caution, don't assume. Different jurisdictions, different plans, different wording. However, even if you have relief at confirmation, sometimes I'll still recommend that you file for relief. And especially, again, like with the Chapter 7, if you don't have your vehicle. Reason being, confirmation hearings from time to time can drag on for, it might be set for next month, but it gets continued because another creditor files an objection or the trustee files an objection to confirmation. And it's not uncommon at all to see a confirmation hearing continued 1, 2, 3 times. And that whole time, even if you have your vehicle, again, you're not able to liquidate yet. And if you don't have your vehicle, again, it's at risk. So generally, unless we're close to one of those, either the Chapter 7 discharge date or Chapter 13 confirmation, I would normally recommend filing for relief from stay as long as we are sure that we can receive either a default order before those dates, or we can receive a hearing date before then, so you're not filing a motion that's going to become moot.
That's right. Thanks, Garry. Another thing we might want to mention is the trustee abandonment. In a Chapter 7, you can't sell that. You might even have that vehicle on your lot at the auction house, but you can't sell it until the trustee has abandoned it. And so that goes hand in hand with a motion for relief. So and it's a depreciating asset. So you may want to just go ahead and get that thing on the auction block as fast as possible so you can realize as much value out of it as you possibly can. Okay, we're moving on to number 5, and Erin is going to take this. Does a debtor have to turn in a vehicle because a creditor obtained relief from stay?
I don't know about you, Monette, but this comes up a lot. Garry, you know, a week doesn't go by where I don't get an email or phone call about this. So let me say this, let's talk about delivery really. If delivery is not possible from the debtor by no fault of his own, and he is surrendering that vehicle, we don't have a good faith issue here, then they don't have to turn it over. And that could be, because the car was stolen or maybe, I don't know, lost maybe. I don't know if you buy that, but now if it's through bad faith, then we have another issue here, and that would be what I would consider the debtor hiding the vehicle, locking it behind a fence or garage, or if you're, in my state, Kentucky, sometimes you find them out, in the southern part in the mountains, hidden somewhere probably. So, yeah, there is no affirmative duty, I don't think, under the bankruptcy code that requires a debtor to turn over the vehicle. Give you an example. If I file, for instance, like a motion to turn over the vehicle because the debtor's not cooperating, there are judges like in Northern Indiana, there's one in particular that will not grant that because he says there's no power under the bankruptcy code that authorizes him to issue an order to have that debtor turn it over. Now this judge is very particular, and he goes by the bankruptcy code exactly, literally. Now I've got other judges that will entertain that to just, I think, for the fact to put pressure on the debtor to turn the vehicle over. So once they see that motion come over, usually it wakes them up and I get a phone call. In reality or in practice, my first step is I pick up the phone or shoot an email to the debtor's attorney. Usually that's what I do first, and then comes part 2 where I make a phone call. And then part 3 gets more serious, and you can consider, for instance, filing for a 2004 exam, which is basically a bankruptcy deposition, and just say, hey, where's the car? It's real simple. Just the annoyance factor alone for debtors counsel, having to, bring his client in, and, that usually gets results fairly quickly. You could, I suppose, file an adversary or something to that effect. I don't think I've ever done that, but I've certainly done some 2004 exams, and I've had that work. You could probably object to discharge for bad faith if they're certainly having affirmative steps. They're, hiding it to some extent, where, or they're threatening your repo man, that type of thing. So if the objection deadline has not passed, that may be an option for you as well. So, and last, I just want to mention there was a case in Eastern District of Kentucky in 2016 where the Judge Schaff talked about this a little bit, and it was one of the first ones I've seen where judges kind of dealing with this. And he talks about basically the difference between surrendering and delivering the collateral. So if you're interested, I can give you that case if you want to read it. But basically, he kind of distinguishes between good faith and bad faith. Depends, whose fault was it that the car can't be delivered. And lastly, the ultimate solution may be to file for what we call replevin. Some states, I think they call it, is it a detinue action? Did I pronounce that?
Detinue.
It's my accent here. So yeah, then that's basically going into state court and asking the judge to do that. And that's the solution that many bankruptcy judges ultimately will refer to. This is a matter for state court and not bankruptcy court.
And I would just add really quick. I agree with Erin that I've had plenty of situations too where usually it's that phone call or that email or both to debtors counsel, and 9 times out of 10 we're able to get it resolved. The debtor's attorney wants to have to deal with that issue about as much as a creditor does. I do have an instance where I have filed a adversary case, but it was slightly different. It did involve a motion for relief. However, it's more of the chicken and egg situation where the debtor couldn't provide the vehicle allegedly because prior to the bankruptcy case, he had allegedly assigned a vehicle to a third party without the creditor's permission, who turns out to be a person who runs a subleasing scam. So that was a situation that rose to a level of fraud, and was a situation where no matter how much we pressured, we weren't going to get the vehicle, even though we had a relief order. So that's always something to keep in mind as well, but that's not the frequent situation.
Yeah. Gary, I had the same situation recently too, where the debtor took a car from Indiana to Texas. And the good news was, he convinced the Texas DMV that something, the title, anyway, they issued a title in Texas. However, they required him to buy a bond. He was able to, finagle the car and sell that, but we made a claim on the bond and got our money back just recently. So that was we didn't have to go to the step of, going through the bankruptcy courts.
Right.
These diabolical debtors, my. One of the downside of this is there's just no easy mechanism. And unfortunately, it is going to cost more fees if we don't get immediate cooperation from the debtor's attorney. That's a big downside, but there's nothing in the bankruptcy court. I mean, this judge that Erin mentioned is right. There's nothing really, short of perhaps a motion for turnover, but I'm not sure that's going to work either. So you are at a disadvantage unless you want to go to state court. But once you have a relief from stay, you can go to state court. So that's the unfortunate answer to that. All right, our next question goes to Garry. Can a creditor proceed against a vehicle immediately upon getting an order granting relief from stay?
So shockingly, the answer is going to be it depends. At the outset, generally under Rule 4001, the Bankruptcy Code provides an additional 14 days after your relief order is granted by the court for the relief to actually be effective. So what that means is that even though you have a relief order in hand, for example, today, 8/26, you can't actually proceed against the vehicle, put it out for repo, until 14 days from that order date. There are some bankruptcy courts that routinely will waive the 14-day stay. Others will only waive in certain situations or just won't waive the 14-day stay at all. So generally, when I send relief orders over to clients, I will mention if the 14-day stay was waived. If there is no mention of the 14-day stay being waived in the order that you receive, don't proceed against the vehicle until that time elapses. In most of my jurisdictions, I do routinely request in our motion for relief that the 14-day stay be waived. However, it's sometimes hit or miss, and it can vary, and it can be the exact same relief situation for Judge A in jurisdiction A today, and he might waive the 14-day stay, and we could approach the same situation next month, and it's not waived. Sometimes there's not a rhyme or reason. Many times I've also seen they're more inclined to waive the 14-day stay if the vehicle is a surrender or you have possession already. So having said all that, you can't put it out for repo or proceed in that way against your vehicle until that time expires, if not waived. You are able to make arrangements to voluntarily pick up your vehicle during that time. So what that looks like is we might get a relief order, and perhaps debtors counsel or debtor reaches out to us or you, or we do the same to debtors counsel and see if we can just voluntarily arrange that, okay, your agent can contact the debtor at this phone number, and debtor's attorney gives permission to arrange pickup, or we can give options to the debtor to turn in the vehicle to any particular dealership and just provide us information of when they turned in and who they left the keys with and things like that. I routinely are able to make arrangements like that. But other than that, no, you cannot proceed immediately unless that stay is waived.
I was muted. I'm sorry. I want to just reiterate something Garry said. Unless the order specifically says that the 14 days is waived, it is not. And what we do, what my assistants do, what our attorneys do is if we send an order to you, we are going to tell you whether or not that 14 days is waived. So you have that built-in protection. But if you are looking at an order and wondering for yourself, if it doesn't say the 14 days are waived, they are not. You have to wait the 14 days. So, okay. Moving on to Erin and question number 7. Does a motion for relief from stay have other possible outcomes that can help with future defaults on the account, even if relief from stay is not immediately granted?
Okay, I guess this particularly pertains to Chapter 13, because in the Chapter 7, usually it's discharged by then, you can go get your vehicle. So in a 13, the typical scenario is, we file for motion for relief and then debtor objects saying that he's going to pay, get current, and want to keep the vehicle. Maybe needs a little help with the arrearages to spread it out over a few months. So commonly this is addressed by filing what we call an agreed order, stipulation, consent order, depends where you're from and what court you're dealing with. But in that, we generally say, okay, you're behind $1,200. We'll agree to spread it out over 4 months at $300 a month on top of your regular payment. So you have to pick up and start fresh with your payment, and then the secondary payment of the arrearages must be made over this period of time. So generally we spread it out where it's over on the 15th is the regular payment and the 30th will be the arrearage payment, just to make it a little easier. Having said that, it is a shot also for the debtor to keep the car longer. There's no intention to pay you all back. So, one provision that we put in the agreed orders, if a payment's not made, we give them generally a 10-day default period. And if they don't make that payment, all we have to do is file a notice of default and serve the debtor, debtor's counsel, trustee, etc. So, it's one way to handle it. Another situation is where they get completely current right away, and then we withdraw our motion for relief. And then what happens? They get, 3 months later, they're behind again. So in that situation, the creditor has to file for relief, spend the money again. So in those cases, we generally, of course, include our fees for the motion for relief and the cost for filing it. So in short, the including a default provision is key within your agreed orders or stipulations.
So Erin, are debtors required to enter into these kinds of default orders?
No, they're not. No, this is purely voluntarily. I would say it's voluntary on the side of the creditor as well. However, the question is, when you go to hearing and the debtor stands up and says, well, I've got the money now. Suddenly at the hearing, they'll always have the money. I can pay back. Well, you're starting, fresh. The creditor has to accept the money, and now you don't have any default order on that you can actually default in without having a hearing. So, I like to try to get an agreed order on pretty quickly, avoid the fact that they go up and cry in front of the judge, and that's usually not a great outcome for the debtor, the creditor.
And I would add too, along with what Erin is saying, normally, even in the situation where we file for relief and either debtor files a response, or especially where they file a response and they pretty quickly cure before we'd have a hearing date, I still try to use that time in between the cure and a potential hearing to see if we can get the debtor to agree to an agreed order, just so that you can avoid those fees and filing fees and the whole motion process in the future. I'd say normally, in my cases, probably 9 out of 10 times we're successful. You sometimes we'll run into, and we learn who these debtors attorneys are, that they won't agree, and there's nothing we can do to force them. And usually, if it comes to that point where it's right before the hearing and we're unsuccessful and they've completely cured and they're getting the car back, at that point in our jurisdictions, or my jurisdictions, usually it's best to withdraw the MFR, because there's nothing that's gonna come to fruition from going in front of my judges with the cured account. But like I said, 9 times out of 10, try, and usually you can be successful, so we don't have to go down that road again in the future.
Right. I had a case, well, I have a case that's open at Chapter 13, and I have local counsel handling it. I'm not licensed in that jurisdiction, but we're on our 3rd motion for relief from stay, and I told counsel, I said, okay, in order to cure the arrears, they have to pay our attorney's fees, local counsel's attorney's fees, and the filing fee, as well as the default, because we can't keep doing this. This is not economical for my client. So, and that's a different end run around the problem. But, and you don't see that very often. Normally, many attorneys will agree to enter into a default order. I usually have a 14-day default period, 10 days. But yeah, that is a very good solution if the debtor is able to bring the account current and they're willing to agree to that. All right. Okay, next question is for Garry. How can a creditor determine if a debtor wishes to reaffirm a debt in Chapter 7?
So there's a couple different ways that you can find out or you may find out. Sometimes the easiest is when the debtor files their Chapter 7 petition, they should be listing, if you have collateral, whether they're going to either reaffirm, whether they're going to surrender, and there's still the option on the form to keep and make payments, otherwise known as retain and pay. So that's one area where you can acquire what's their intention. Are they intending to reaffirm? Another way, sometimes happens along with that, sometimes before or after, is either debtor's attorney or debtor themselves may reach out to the creditor or our office if they know we have the file, and they may ask for us to send a reaffirmation agreement to them. What I would also caution is, just because a debtor states in their statement of intention with their petition that they are not going to reaffirm, they're going to maintain payments, I still usually would recommend sending a reaffirmation. Other than, if you're sending them yourselves or we're sending them, other than the time or the fee, there's not a downside. If you can, through sending that reaffirmation, maybe convince a debtor here or there that there's positives to them reaffirming, that's even better for you in the end. But a lot of times in those situations too, if they indicate they're not going to reaffirm, they probably won't end up signing the reaffirmation. But I have seen it happen as well.
Okay, thanks, Garry. Now, Erin, the question for you is, now that a creditor is determined that a debtor wants to reaffirm, what should a creditor do?
Well, I think time is of the essence here, so you want to get that reaffirmation agreement out immediately. And we'll talk about the deadlines here in a minute, but you know, I prefer to send it out, and you know, any party can actually file the reaff agreement itself. Meaning the debtor can file it. I prefer the creditor to file it, because once we send it out to debtors counsel, I don't know if they can change. You know, there might be some slight little addition they add to the reaff agreement or something to that effect, or just don't fill it out properly. We get once a week, we get a reaffirmation agreement back. Boxes aren't checked, or you know, lines are blank, things like that. So the creditor should remain in control of this reaffirmation agreement, in my opinion. So when we send it out, we get it back, then we can review it and see if anything's missing. So that's one reason I think the creditor should get it out immediately, you know, and get it back to review so they can have it filed, you know, and review for any changes that possibly could be made as well by the debtor.
Okay, and our next question, number 10, is for Garry. Can a debtor reaffirm a vehicle lease agreement, or any lease agreement for that matter?
Sure. The short, simple answer is yes. If you're talking in the vehicle world, compared to a vehicle purchase, which you reaffirm, the vehicle lease agreement would be what we call assumed. Many jurisdictions, and it differs from jurisdiction to jurisdiction, unfortunately, many times the process is the same, and it may be accomplished through a reaffirmation agreement, just as if it was a purchase. However, there are some districts, and I found lately there's more and more moving this way, and we don't actually know until we try to file, that have other requirements in place, where either they require just a lease assumption agreement, or they require a reaffirmation agreement along with a lease assumption agreement, or in the situation, which is what we have in Western PA, and I've seen in North Carolina and some other places too, that you need to send the lease assumption agreement to the debtor or debtor's attorney. They'll execute and send back to you, and after you execute, that's still not enough. You then need to have an attorney file that lease assumption agreement along with what's called a motion for lease assumption. And for example, in Western PA, when we file those, it's the normal motion process. So just like if you were filing an MFR or another motion, we file that lease assumption motion with a lease assumption agreement. The debtor or other parties have the normal response period, which in Western PA is 17 days from filing a notice. And then after that point, if there's no response filed, the court will issue a default order granting our lease assumption. And there could be a response filed, but honestly, I've never had a response filed to them. So unfortunately, in those situations, it's a little more expensive because you're expending the cost for the motion and the filing fee, which my theory lately, when some of these other jurisdictions have started changing their local rules or indirectly been going this way, it's a way for the courts to get that filing fee from you, where normally they wouldn't be incurring that extra revenue. So it depends by jurisdiction.
All right, thank you, Garry. Erin, question 11 has your name on it. Is a creditor bound by any deadlines to execute a reaffirmation agreement?
Yes, under, I think it's bankruptcy rule procedure 4008, something like that, that you have basically 60 days from the 341 meeting of the creditors to file your reaffirmation agreement. That also coincides generally, excuse me, with the the discharge date generally occurs right after that. So the severance, the deadline truly is that discharge date. So the latter of, I think, is okay, as long as we get it in there filed by the discharge date. But technically under the code, you have 60 days from the 341 meeting.
Okay, and now I have a trick question for you as a follow-up. What if debtor obtains a discharge, the reaffirmation has not been filed, but both the creditor and the debtor and the attorney signed it before the discharge was entered? Can that reaffirmation agreement be enforced?
Can I say on that, Monette?
Okay,
Let me scratch my head. In my opinion, the date of discharge severs the ability to file the reaff agreement, even though it was signed prior to discharge. Having said that, I've seen people file a motion to reopen a bankruptcy case that was closed and then filed to vacate the discharge so they could file the reaffirmation agreement. Not all jurisdictions, I think, allow that. I don't think Indiana or Ohio does, but I'm not going to say 100%. But that would be the only situation I can think of. Now, I'm not saying you can't file it. I've seen people do that and file it. I'm just saying if someone challenged it, perhaps it would not hold up.
yeah, in Chicago, if the reaffirmation agreement is signed before the discharge is entered, you can still file it after the discharge and it will be valid. So
without vacating the discharge?
Correct.
Wow.
Yeah. It's filed. As long as the case is still open. As long as the case is still open. If
Right.
the case is closed, then you'd have to reopen it. But yeah.
We had one in Western PA recently that debtors counsel had sent over to us. They had their discharge. I think the case may have actually even closed, and he wanted it filed, so we filed, and the court said no. However, so that was the bad news, but the good news was the court in their order stated that since the parties entered into the agreement prior to discharge, that it would be enforceable outside of the bankruptcy court. Just stated they didn't have jurisdiction to take any action because of the discharge. So we still ended up getting what we wanted.
Okay, so it sounds like this just goes by jurisdiction. So you need to ask your attorney that's handling your case, what if this situation occurs.
Okay, having said that, Monette, if I did get one and the case was not closed, would I file it? The answer is yes. I think it's important, though, in the mind of the debtor, they think the agreement is still valid, whether it is or is not. I would rather have that in their head, making the payments and feeling an obligation to make those payments. So I would do it anyway.
All right, absolutely. Okay, and our last question of our presentation before we get to the audience questions, what actions and this is for Garry, what actions may a creditor take if a debtor did not reaffirm a debt?
So at the outset, just keep in mind that even though that debtor didn't choose to reaffirm on your account, until that Chapter 7 is discharged, that automatic stay is still in place while the bankruptcy case is pending. So if instead of reaffirming, they chose to surrender, as we talked about before, many times you're going to need to file a motion for relief from stay so that you can liquidate. Again, going back to what we talked about as far as what your dates are looking like and when discharge is happening. If they choose to just keep maintaining the payments, retain and pay, once the case discharges, you still do retain your lien rights. So you can still secure the vehicle, foreclose on your property if they fall behind on payments or there's another default such as canceling insurance. And in addition to that, if it's early enough in the case and they state that they're going to maintain payments and then they start falling behind, you should also consider filing for relief there. Just also keep abandonment in the back of your head with that as well. The key thing to remember too is if it's not reaffirmed, once that discharge order is entered, the debtor's personal liability for that debt, meaning for any monetary balance they may owe you, is discharged. You cannot pursue the debtor personally for any balance on your account. However, as I mentioned, you can still secure your vehicle and then liquidate and apply those amounts to your account.
Okay. All right, let's go. We had some questions from our audience, and let's go to the first one that Erin is going to answer. And the question is, are there certain loan documents we should be including in the reaffirmation agreements when we file them?
Well, certainly there's a cover sheet that goes along with the reaffirmation agreement that has to be filled out by either the debtor or the creditor and signed. So that must be accompanied and filed with the reaffirmation agreement. It's, I think, Form 427, the cover sheet. But as far as attachments go to the reaffirmation agreement, I am not aware. I have heard some jurisdictions require or used to require at least I's and J's, that is from the bankruptcy petition, the schedule for income and expenses to be filed with the reaff, and that may just be for convenience sake for when the court looks it over. They have that in front of them to compare, the income that you put on the cover sheet along with the debts that you put on the cover sheet. But other than that, generally no, we do not. We just file the reaff with the cover sheet.
I'll just add in.
Sorry, that's so in all of my jurisdictions as well. All right, next one for Garry. Question number 2. For credit unions, if a reaffirmation is filed, is the stay lifted or not until discharge?
So generally, as is the case with a lot of situations, I advise just take the safest path while that bankruptcy is pending. So even if you file the reaffirmation agreement and it's either approved or it doesn't require court approval, and the debtor becomes due for those payments that are filed under the reaffirmation agreement, since that reaffirmation essentially serves to make a pre-petition debt under the new agreement post-petition debt, there are some things you need to watch out for that can happen without you realizing when you're moving on your account. And these can result in that reaffirmation agreement that previously was valid and enforceable no longer the case. That can include if the debtor is pro se, whether it's a credit union reaffirmation or not, that will require court approval. If the debtor rescinds the agreement, which they have to give you notice, and it's either before discharge or within 60 days of when the reaffirmation was filed, whichever occurs later, that can be an issue to watch out for as well, and a stumbling block. As well as if your reaffirmation agreement has a presumption of undue hardship, court approval will be required if it's not a credit union reaffirmation. So what I recommend is, if you do have a valid and enforceable reaffirmation that either was approved, didn't require approval, and has not been rescinded, I would advise reaching out to debtors counsel if those payments fall behind. And normally it's in the debtor's interest to cure those payments. And I've not come across a situation that didn't happen when we reached out. So that would be my safest and best advice if you come across those situations.
Okay, thank you. All right, next one is for Erin. Do creditors have to allow a reaffirmation agreement if the debtor is delinquent?
No, in short, no, they do not. And nor does a creditor have to allow it as well, even if they're current. So that's a short answer, but no, they do not have to.
So reaffirmations are voluntary in short. All right. All right. Question number 4 for Garry. In Delaware, the court always rules reaffirmation agreements unenforceable. Is there any reason to continue preparing them?
So generally, yes. As I mentioned in my previous question, there's multiple reasons why the court may find that filed reaffirmation is not approved. It could be an undue hardship. In Delaware specifically, what I found was the court has actually put out a memorandum opinion by the chief judge that follows the bankruptcy code, that if you have a reaffirmation agreement where the debtor is represented by counsel and that reaffirmation agreement is filed and the attorney certification is not signed by debtor's counsel, the court is not going to approve your reaffirmation agreement. So that, from what I've seen in Delaware, that is a common occurrence, but that's not going to be specific to Delaware. The code provides for that nationwide. So as Erin had mentioned earlier, the best way to ensure that your reaffirmation agreement is not altered, the terms are not altered that you're going to be bound to, the attorney or debtor fail to complete a portion, is to send out the reaffirmation agreement to them. However, don't countersign the reaffirmation until you receive it back and request that it comes back to you. That way you can review to make sure for completion, for all signatures, and you can file it yourself and be in control, that there's nothing that you missed or debtor's counsel missed that could cause you any problems.
Okay. All right. And then question number 5, we're getting to the end of our session here, so we'll get in as many as we can. Are there specific courts or states that will allow borrowers to ride through a Chapter 7 by remaining current on the payments? And that's for Erin.
Well, remember in a 7, you have 3 choices under the code. You can, return a vehicle, reaffirm a vehicle, or redeem a vehicle by paying the full amount or full balance of the account. There is sort of an unwritten 4th option, and I think Garry had talked about that too, the retain and pay. It's not really specifically laid out in the code, but it's common among some jurisdictions. Certainly in Kentucky, it's kind of common, Indiana. So I can't answer whether all specific courts or states allow that. I know my jurisdictions do. As long as the person's current, at the end of the day, the bank or credit union, they want to get paid. They don't want the car back. They don't want a depreciating asset. They want a return on their investment. So in my opinion, if they're current, despite the fact that they haven't reaffirmed, let it ride through. I don't think that's an issue, and it's fairly common, at least in my jurisdictions.
Yeah, nothing wrong with getting payments. All right, the next one is for Garry. Must a loan be up to date in order to reaffirm?
No, there's not a requirement that it must be current in order to enter into the reaffirmation agreement. Just like we mentioned earlier, reaffirming is voluntary on both sides. So many times creditors will not offer a reaffirmation agreement unless the account is current. There's many times where debtors counsel will reach out and see what needs to be done to reaffirm, and at that point we'll mention the arrears that they need to be cured. You can enter into a reaffirmation and notate in there that there are arrears to cure. You could also modify your account because this is a new contract, a new agreement anyways. But in short, no, there is no requirement under the code that a loan has to be current in order to reaffirm on it.
Okay, thank you. All right, next question is, looks like Gary's going to take this. I'm concerned that the government is trying to have student loans be able to be discharged in bankruptcy. Are there any updates on this?
So recently there was actually pending bipartisan legislation that was introduced in the Senate that offers a proposal to possibly allow student loans to be dischargeable 10 years after they first come due. However, it was just recently introduced. There are not indications yet if this will apply just to federal loans, federal and private, or if there's going to honestly be enough support to make it out of the Senate, let alone pass both houses, especially with the narrow divide. There's been some other proposals in the past year that have not been brought back to Congress yet as of today. And as of now, there's not been any changes that have been made to the current code and environment. However, we continue to monitor if there's any changes, and if there are any, we'll be sure to let everybody know.
Right. Okay, I'm going to squeeze in the last question here. And this is for Erin. How long do you have to wait to repossess after a discharge is entered? And does it matter if the person filed bankruptcy without an attorney?
No, it's immediate. As soon as discharge is entered, the stay is lifted, and you may proceed. With repossession. Now, assuming the case is, case could be still open, possibly, and the trustee hadn't issued his abandonment in Chapter 7, that may be an issue, but you could still certainly, repossess it and file for abandonment.
Okay. All right, well, we're out of time. I did get a question through our chat feature, and a couple of them. I can't get to these, and one about the mortgage. You might want to please just go ahead and contact me directly. My contact information is on the screen, and I can answer that question. There's a lot of what ifs, and I need more information in that question. Okay, well, thank you everybody for showing up and participating in our webinar. I do hope you learned something and that this was informative. We are all available. If you have follow-up questions, contact any one of us and we'll be glad to answer your questions. So I hope you have a great rest of your day. Thank you.
Thank you. Appreciate it.
Thank you.